Hello, everybody. Apparently, Ava felt like I needed help there.
Every bit, yeah. If not all. If not all. Yeah.
Mr. Granderson. Mr. Bassad.
Good morning, Judge. I'm here on the Granderson sentencing. I'm on a quick break with my hearing now, Your Honor.
Okay, well, good morning, but this is in person, counsel. Do you have permission to appear via Zoom?
I was told each sentencing was done by Zoom, Judge. Because we zoomed
No,
in all the prior hearings.
No, on Thursdays, the only thing that's on Zoom are PCCs.
Oh, really? That's new to me, Judge. And I truly apologize. I'm
Not sure why that's new, because that's how it's been. The only sentencings that are permitted on Zoom are on Tuesdays.
So I apologize. I didn't know there was a distinction between the Tuesday and Thursday sentencings.
Okay, so how long until you're here, counsel?
Well, Judge, here's the problem. I'm literally right now as we speak. And this is no lie, Judge. I'm literally in another trial right now. So we were on a break now, with the jury, Judge. But I don't know if I can leave today and come down in person. And honestly, I didn't know there was a
Where's the
distinction.
Granderson file, please? Hold on, counsel, please. Hold on. Do you have the Granderson file right there? I believe we already adjourned it because you were in trial previously, correct, counsel?
I will. That was in a murder trial 2 weeks ago, the last time, Judge, and I'm in a jury trial today. So I do apologize.
Thank you. Counsel, do any of your notices indicate that you're appearing via Zoom?
Judge, my previous ones have, Judge, and I was on the record on Zoom. Judge, that's why I said it was never, even when I spoke to probation, I got an email one time saying that the sentencing was by Zoom. So I'm really not making that up, Judge. I'm really not.
Your email indicated that it was via Zoom. That's what you're telling me, counsel?
I said the email that I received from the probation department
Told you that this sentencing was on Zoom.
That was my
talking to everybody else. He called me,
he
talked to me, but when she did,
I'm sorry, somebody was speaking over you. What was that, counsel?
No, I said that was always my communications, Judge, and I'm not making that up, Judge. I'm really not.
I'm not understanding what your communication was.
That the sentencing were being held by Zoom, Your Honor. And this was
Counsel,
directly at the time that my client.
Hold on. You have an emergency motion to vacate conviction, so it's a motion hearing also. I do not do motion hearings via Zoom.
Judge, if you look in the file, Judge, that motion was denied. You denied that motion, Judge. And the only hearing I missed was the last one because I was in trial, and now I'm in trial again today. But that motion hearing you denied.
No, counsel, I denied the December 4th date, and I denied the emergency basis. I didn't deny the motion. We haven't done a motion hearing on it.
Judge, I submitted my motion. I got an email from the court saying that the judge denied your motion to vacate count 2. And
okay, counsel, counsel, I'm going to step off to double check and see what communication you've received, because I'm reading my notes right here. Emergency status not granted, set for hearing November 13th. Okay. Then November 13th, you sent in an emergency stipulation to adjourn pretrial, and you wanted it to be set for December 4th. The court denied that date and set it for a different date. The court has never denied your motion, counsel.
Judge, Judge, listen. I can email the court and show you exactly what the court emailed me.
Counsel, did you just tell me to listen? Is that what you just said to me?
I did not say
I just said I'm going to step off to see what communication you've received. But I do not appreciate being told to listen. So I'll be with you in just one moment.
Everyone please rise.
we're not.
You may be seated.
We'll stop. Mr. Morski, I need you to hit the join on the breakout room. Okay, it looks like she's joining now. Okay, let's go. Let's go on the record in the matter of Darius Grandison, 251089. The state of Michigan was Darius Grandison. Counsel, your appearance for the record again, please.
And good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Mr. Darius Grandison, who's present in court. Mr. Grandison, please state your name for the record.
Darius Grandison.
Okay, so counsel, let me just go through this procedure here. You were here for probable cause conference and you were in person on an exam on September 4th, for an exam on September 4th. It was not held, your client pled to a misdemeanor. Then this matter was scheduled for October 14th for sentencing, which I believe you were in person for. And the sentencing was not held. You adjourned it to resolve count 2, and then you were going to be submitting a motion to withdraw the plea on count 2. And the sentencing was adjourned to November 6th. November 3rd, the court received an emergency motion to vacate conviction. The court reviewed that, and the court made a note on November 3rd, emergency status not granted, set for hearing November 13th, removed sentencing from docket and adjourned to November 13th. Okay. You received an email on November 3rd. Judges reviewed and denied the emergency motion. The motion and sentencing have now been set for November 13th. So there was a miscommunication with some of the language that was sent to you. However, it also indicated that the motion and sentencing had been set for November 13th. So I denied the emergency status of your motion, but did not deny your motion, counsel. Then you had sent in a stipulated order to adjourn the pretrial. And then ultimately that was granted, but a different date. Then you were still stuck in the homicide trial. So we set it for today's date. And now here you are on Zoom for a motion hearing and a sentencing, which we are not doing via Zoom.
I understand, Your Honor, and no disrespect to you or your court judge, but Your Honor, I just got called back into this court with this trial judge. This trial was set for December 2nd. It was supposed to be over with by December 4th. Then it got moved to today. And Judge, I've had no time to let the court know in your case, but I'm not trying to disrespect you or your court, Your Honor. But Judge, I literally just got called back into my court for this trial, Your Honor.
Counsel, can you be here next Thursday, December 11th?
I will be there, Judge, with
Person
flying
for your
colors.
motion hearing and your sentencing.
Thank you, Judge.
December 11th, what time, Ally? At 10 a.m. And counsel, just for future reference, please do not say, listen, judge, okay? Did he just sign off? Are we for real? Did he just sign off?
The sentence.
Mr. Granderson, we'll see you back on December 11th. It's not your fault, sir. 10 a.m. Okay, does that work for you?
Yes.
Okay, and I do apologize that you're continuing to be here. And I'll say that sometimes some court things are outside of the control of the attorneys. Sometimes you can't guarantee or the length of a trial is sometimes out of the hands of the attorneys. So, but had you had any communication with your attorney?
Not about that, no.
Okay. All right. We'll see you back next week.
See.
Have a good day.
It's a.
You can put him on our list that has to appear in person, not on Zoom for anything. We'll be here at the time of 10 a.m. Can you please send an email to Mr. Bassant letting him know that the court was still speaking to him when he abruptly hung up?
I'm sorry.
Please, I'm talking to Ally.
Okay.
Okay. Who's next? Do we have the Baird file? Let's go on the record in the matter of the state of Michigan versus Paul Baird II, 25630.
Renee Cooper on behalf of Mr. Beard. Unmute yourself, sir. Give us your full name.
Paul Birdie Baird II.
Thank you.
Okay, so today was the date scheduled for a review in this matter. Your client was referred for competency June 26th of this year. The review scheduled for August 28th. The order for competency was emailed to CFP by the court on June 27th. And then August 28th, the review was held. Defendant's interview date was September 9th. We adjourned the review date to October 30th. On October 15th, we adjourned the review date to December 4th because we had not yet received the report. Yet, apparently, Mr. Baird failed to appear for his evaluation.
What? No, he went to his evaluation, Judge.
Yep.
Well, here's what I have dated October 24th. Do you have something dated October 24th, counsel?
No, Judge. I just spoke with Mr. Beard when he came back from his interview. That's what I'm basing my statement on. But I
have a communication dated October 24th indicating the defendant was initially interviewed by the center on September 9th, but due to unexpected circumstances, the originally assigned forensics examiner is unable to complete this evaluation. As such, the defendant was rescheduled for evaluation to be performed by this examiner on October 22nd. However, this is to advise the court that we are unable to comply with Your Honor's order dated June 27th to perform the competency evaluation of the above referenced defendant in court case owing to the defendant's failure to present to their appointment at the time and place designated by the center, which is for October 22nd, 2025 at the Center for Forensic Psychiatry. Did you show up on October 22nd, sir?
No, Your Honor. I showed up on
So, counsel, that's what
October-
happened. Sir, you answered no. You did not show up on October 22nd. You showed up on September 9th, and I just read in the letter, you needed to have another evaluation, a rescheduled evaluation done, which was set for October 22nd. You did not show up for that.
Okay, Your Honor, I was never notified that I needed to show up in September or ever again, by anybody. So I went on September 9th. Actually, I went once before that, and they told me that I wasn't scheduled until September 9th.
Well,
So I
sir,
went back on the 9th and I did
Excuse me.
whole evaluation.
excuse
And
me,
then
excuse me. How were you notified to be there on the September 9th date?
because when I showed up early, a week or so before September 9th, I think it was like September 4th or I don't even remember what day it was. The forensic center gave me the paper that they were mailing to my lawyer and to you guys to schedule it for the September 9th. And
Sir, let
I
me
received-
clarify. The court has nothing to do with scheduling. We are not a middleman for scheduling, not at all. The only thing we do is send the order. Mr. Cooper, did you receive notice of the date for October 22nd?
I did not, Judge.
Well, so counsel, what is it you want to do? You've requested a competency evaluation for your client's charge of possession, controlled substance, second offense notice, and he didn't show up for the October 22nd date.
Well, in more recent discussions with my client, I'm wondering whether he needs a competency examination at all at this point. He has changed significantly, and I'm sure it has to do with not using controlled substances and I suspect that's true. Am I correct, Mr. Baird?
yeah, definitely.
Right. He's much more clear-headed, Judge, and at this point, I wouldn't think, if I got this case today, I would not ask for a competency evaluation. So, with that said, I don't think we need a competency evaluation, and I want to withdraw that request.
Okay, so did you speak to the prosecuting attorney regarding a resolution or no?
No. No, I think I should talk to Mr. Baird in a breakout room. I think we can resolve this today pretty quickly.
Okay, we'll put you back in a breakout room.
All right.
Thank you. Council, I just have Mr. Beard, and then I will get to your, the other two. For a recall of the matter of the state of Michigan versus Paul Beard, 25630. You're muted, Mr. Cooper.
I'm sorry, Judge. Renee Cooper, on behalf of Mr. Beard, give us your full name, sir.
Paul Bertie Bear II.
All right.
Thank you.
And so, council previously withdrew his request for competency evaluation for his client. And that was based upon Mr. Baird not being under the influence of any substances, and therefore, council believing that Mr. Baird is competent. Is that accurate, council?
That's very accurate, Judge, yes.
All right. All right, and so council, you had an opportunity to speak with the prosecuting attorney regarding this matter, correct?
I have, and I've discussed it with Mr. Beard. He wishes to waive his exam at this point.
All right, and so Mr. Baird, you do understand that you do have the right to have a preliminary examination where it must be shown that a crime is committed and probable cause exists to charge you with that crime. Do you understand that?
Yes, Your Honor.
And you also understand by waiving your right to your preliminary examination, you will be bound over to circuit court for further proceedings on the charges in the complaint and warrant, correct?
Yes, Your Honor.
And you received notice of those charges in the complaint, correct?
Yes, Your Honor.
And has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
Oh, no, Your Honor.
Counsel, any objection to the court indicating via Zoom on both your signature line and your client's signature line?
No objection at all.
All right, the court will note examination having been waived, defendant's bound over to circuit court for further proceedings. You are to appear in circuit court on December 18th at 9 o'clock in the morning on the charges in the complaint and warrant. The court will order bond and conditions are continued. Good luck to you, sir.
Okay.
Thank you
Your
much.
Honor.
Thank you.
much.
Have a good day.
Okay.
You too.
Right.
Be safe, be well, sleep sweet, and much love.